Hello.
Yes. Sorry about that. I was transferring from my phone to my laptop.
It's
So
fine. It's
you
fine.
said
Yes. George, it seems we've lost you. Okay, now the other person was Omuronji Esther. Esther, please go on.
Brian, can you repeat the question, please?
Okay, the question is, you have three parties. Kimani was driving. Esther Kimani was driving a motor vehicle along Mombasa Road. She went on and hit Oduor. But because Oduor was hit from the back, it subsequently led to him hitting Mr. Arunga. Now, Arunga, there's a cause of action. Arunga was hit by Oduor. So he institutes a claim against Oduor. What will Oduor do in that circumstance? I can't hear well. Is it my connection or is it George's connection? Can you hear me? Hello, can you hear me?
Yes, we can, but we can't hear George.
George. Okay, his net is a bit shaky. Maybe who else wants to attempt? Arunga, you've talked today. Muturi, Nyabia, you've talked. Masika Joy. And also Muronji. Muronji, actually, your hand was up. Okay, but you asked. Okay, Masika Joy, please go on. What will happen in that circumstance?
I think that I can't remember the names if it's Mr.
Okay.
Oduor and but the defendant in that case can seek leave in court to give notice to Esther, a third party notice, and that application is usually done ex parte through a chamber summons plus supporting affidavit. I think
exactly. So we are doing what? We're doing a chamber summons together with supporting affidavit. Now, my follow-up question is, because your hands are up, Omuronji Esther, why are we doing it via a chamber summons and not a notice of motion? What informs that decision? What informs you to draft a chamber summons and not a notice of motion? Esther? So then I want to show you how you will know. Once you know how a chamber summons is drafted, how a notice of motion is drafted, the next difficult task is identifying where do you use a notice of motion, where do you use a chamber summons. Will you cram all those provisions? There's a way you will know. So the question is, what will inform your decision in that circumstance, as has been pointed out right now by Masika, to use a chamber summons and not a notice of motion? Anybody with the hands raised up, you could speak. Yes, please go on.
Yeah, I believe the guide is the rules. But also, the guide is the civil procedure rules.
Yeah.
But also, you'll find that most of the time, chamber summons are done where the application is ex parte. You don't need to serve, and the order sought, for example, in that scenario, you don't need to serve the other party. They are granted ex parte.
Okay, yeah, that's a good observation. Now, I'll highlight my civil procedure rules here. This will actually teach you in practice. So this is the civil procedure rules. That's a very good point. The reason why I will draft a notice of motion, a chamber summons application is very clear. It's because it's provided for in the civil procedure rules, expressly provided for. Issues to do with third-party proceedings. Now, to answer the question, what will happen in that circumstance is Oduor the defendant will institute third-party proceedings. He will seek leave of the court to institute third-party proceedings. The provision is what? Order 1 Rule 15, which you can go and read at your own time. Now, under Order 1 Rule 15, you will come down here and check something here. There's a paragraph. It shall apply to court within 14 days after close of pleadings for leave of the court to issue a notice, herein after called a third-party notice to that effect, and such leave shall be obtained by what? By summons in chambers ex parte supported by an affidavit. That is why you do a chamber summons. It's not because you are told by the lecturer. It's not because you've read it from a book or something. It's because the civil procedure rules expressly provide for it. Yeah. Now I'll give another example. We've discussed that party proceedings. Now let's talk about interpleader proceedings. Now in interpleader proceedings, the issue is there are two people contesting. Okay, before I go, what's an interpleader proceeding? I'll mix these up, oral questions, I'll ask questions, and then now we explain and now show you. What's an interpleader proceeding? Odor, please go on.
Is when the party who is and this party is by two different people. So this party is neutral. They haven't colluded with any party or any of the two parties, and they are ready to follow the court's direction in order to give out this property to the right person. So the main reason as why this person is coming to court is so that the court can decide the person who is supposed to have this property, than this person giving the property to the one of these guys and getting into legal issues in the future.
Yeah. Good. That's a good thing. That's a good thing. Now, interpleader, they may arise in two circumstances. Many guys had risen their hands up. I had even seen Stephanie. Stephanie, don't lower your hand. There are two circumstances where an interpleader will arise. What are they? In two situations where it will arise. It can arise in a pending suit, or it can arise from a fresh suit. Yeah. Now, I'll ask, in a pending suit, even interpleader, what Odora has explained, if it's in a pending suit, what will you draft in court? How will you approach the court? Stephanie, please go on.
Good evening.
Good evening.
It's in appending court through a
chamber summons. Exactly. Now tell me why. Why is it?
Because you're seeking the
Because
you're seeking the orders ex parte.
Because you're seeking the orders ex parte. That's a good one. What else? That's true. That's very true. What else, Nyabio? I'll open for you. It's under order 34. Just open it. And these are highly tested areas. Even if we're doing some drafting here, I'm just giving you some bit of background, then we proceed.
Solanka, I actually wanted to say what Stephanie said.
What Stephanie said,
Yes.
Okay. Now, that's very true. You guys had it very correctly. You've put it very correctly. But another and a very simple and obvious reason is because it's provided for in order that for the civil procedure rules that you do what? You approach the court using a chamber summons. You can just check it out here, order 31, order 34 rule 1. What does it say? An application for relief under this order shall be made by originating summons unless made in a pending suit, in which case it shall be made by summons in the suit. So if it's in a fresh suit, it will be an OS. But if it's in a pending suit, it will be a chamber summons. Yeah. But there's actually a very interesting point. If you check section 58 of the Civil Procedure Act, it provides for notice of motion. Food for thought. But it's something I raised with the lecturers, and we mooted in class last year some conflicting provision because the Parent Act provides NOM. This one provides for chamber summons. But they gave me an answer that I wasn't satisfied, but that's fine. So you're getting where, so those are two circumstances we have put out where a chamber summons is used. When it comes to third party proceedings, and when it comes to interpleader proceedings. And now my other question arises. Okay. Now, the thing there's something to do with addition and substitution of parties. What application will you draft in that circumstance? Addition and substitution of parties. So let's say, for instance, you've instituted a suit against person X. Then you realize later on, no, it shouldn't be person X. It should be person B. How will you go about that situation? How will you go about that situation? You've instituted a suit against the wrong party. Now you need to bring in the right party. How will you go about it? Somebody wants to attempt Viola?
I think under that, you will submit through order 1 with 10.
Exactly. Which application will you use?
Chamber summons.
Why will you use a chamber summons?
I think it's provided for under order 1. I can't remember which rule, but yeah.
Here it is, order 1 to 14.
Okay, thank you.
Yeah. Any application to add or strike or substitute a party or defendant may be made to court at any time before trial by chamber summons or at the trial of the suit in a summary manner. You see, they're providing for expressly that you use what? A chamber summons. And this is what we'll do today. We'll distinguish between a chamber summons and a notice of motion application. Where they're used, where they're not used, where each of them are used, and why you use one and why you don't use one. So from what I've explained to you right now, you can see for chamber summons application, it is expressly provided for in the Act for circumstances where you use it. If it's not provided for, like for instance, if the Act is silent on it, you will use a notice of motion application. And the reason why you use a notice of motion application is by virtue of Order 51 of the Civil Procedure Rules. Now, this is something, if you're going to do if you want to do litigation, you'll have to read this thing in and out. You'll have to, even for exams and even orals, because it's, most questions come from civil, because civil is extremely broad. From commercial litigation, civil arises. From, just civil, most oral questions come from civil, and civil, criminal draftings and all, and so forth. But yeah, this is it. If we check Order 51 of the Civil Procedure Rules, it says all applications to the court shall be by motion and shall be heard in open court unless the court directs the hearing to be conducted in chambers or unless the rules expressly provide otherwise. Now, tell me, what is your interpretation of that? I'll just leave it out there. What is the interpretation of Order 51, Rule 1? And this is the question that is usually asked. What is the difference between a chamber summons and a notice of motion? Where do you use a chamber summons? Where do you use a notice of motion? So my question is, somebody please interpret for me Order 51, Rule 1. What does it mean, this provision over here? Picking those who haven't talked. Kiplagat, Jebkoech, please go on.
In my interpretation,
Yeah.
I believe that it says that a notice of motion is a default application.
Exactly. It says the notice of motion is a default application, meaning if an act provides for you to use a chamber summons, use it. If it's silent, what will you use? A notice of motion. Yeah. And in all circumstances where you'll see somebody using a notice of motion application, there are so many things. Interpleader, there is parties to a suit, there is that party proceedings, there's issues to do with professional undertakings, there is default judgment against a third party, and so also. But if you see anything pertaining to Order 1 of the Civil Procedure Rules, it's a chamber summons application. Now, a notice of motion application is what? Is a default application, meaning I'll give you one instance. Let's check order. Where is it? can take order 40, for instance, injunction. When you're making an application for injunction, what will you use? You will use a notice of motion application. Summary judgment, order 36. So this is another question. You need to distinguish between summary judgment and default judgment. A highly tested area in civil litigation. So today we'll do civil. Next week we'll do I'm good at commercial, civil, criminal, and conveyancing. My main issues in Akuzaga in ethics, but my colleagues Kina Lavins will take you guys through ethics. Probably, I didn't have a particular liking to it. But yeah, so order 36. If you're bringing an application for summary judgment, you will use a notice of motion application. If you bring in an application for stay of execution, you will use a notice of motion application. That is order 42, rule 6, and so forth. So right now, don't stress yourself. I know maybe you've not reached there, but I'll just go on ahead and show you how to draft these sample documents. So I'll show you how a notice of motion is drafted, and I'll show you how in the next 10 minutes, how this thing, what's it called? Chamber summons. We'll do those two today because we can do all the others. Because in an exam, civil, like our number one question was a notice of motion. So Nikitu always miss, you won't miss it in class. So we can start with the notice of motion. So I'll show you a notice of motion. Now, for instance, let's say we're doing a notice of motion for what? Let's do the most basic one. It's for an injunction. Yeah? So when you're doing these questions, somebody confirm. Can you see my screen?
Yes, we can.
Yeah.
Okay. So to pass exams, you don't need to know how to draft all these things, because they have so many papers. Yes, I have a perfect document, but I show you in 30 minutes you cannot draft the most perfect document. Just show the lecturer that you have an idea and you know. So the hypothetical question is, who do I use? I'll use a Bogi Tony. A Bogi Tony, you have your client comes to your office and he says he's about to be evicted. Yeah? He's about to be evicted from his land. What will you do in that circumstance? You will rush to court. You will do what? You will file an application. So let's say there's a substantive suit already in court. You will file an application. The application will be an application for injunction. Now, the application for injunction will be just a notice of motion application by virtue of by virtue of the civil procedure rules, order 40, right together with order 51 and so forth. So Republic, you have to start with the Republic of Kenya. You go to, what's the jurisdiction? This is another thing that I test in exams. Jurisdiction, environment and land matters. Which court deals with them? The Environment and Land Court. Yeah. At the same time, you also need to check what the pecuniary jurisdiction. So for this, I'm presuming the pecuniary jurisdiction is above 20, and that's why I've gone to the Environment and Land Court. So Environment and Land Court at Nairobi. What else? ELC case number dash of 2021, and you're done. That's usually maybe a mark. I think that's a mark or so. Yeah. So you list the parties. XXX. Okay. Say just use Esther money. Is who? The plaintiff. Stroke applicant. Versus we'll use Odor is the defendant stroke respondent. The defendant stroke respondent. So after you're done with that, you've properly described the parties, you've properly labeled them, you come down here and you write notice of motion. Done notice of motion. Now you have to put the enabling provision. So this is this is where now I'm saying you have to read the civil procedure rules. It's because of issues like this. You need to at least show there are basic provisions you need to know. Order 40, order 51, zingine we will do them pole pole. So there is under 40 and 51 of the civil procedure Civil Procedure Rules 2010. Then what else? So other lawyers throw in these things. You've seen them do under section 1A. There's 1A, 1B, and then the inherent jurisdiction of the court. But the most important is order 40 and 51. At least the lecturer knows, you know what you're talking about, you know your stuff. And 3A of Civil Procedure Act. Usually Cap 21, yeah. So you're done with that. So the next step is, this is the most crucial bit. The next step is coming to draft your, now, how do notice of motion start? Anybody just unmute and tell me how you begin. How do you begin a notice of motion application?
Take
Notice.
notice that
This on
it's honorable on the dash day of dash 2021 when cancelled for the applicant to be heard for orders.
Exactly. At what you have to show the time also, at 9 o'clock.
soon after in the forenoon.
Yeah, 9 o'clock in the forenoon.
Also soon thereafter.
Or soon thereafter.
When cancelled for the applicant shall be heard.
Yeah.
For orders.
We had an application for the following orders. Yeah. And actually, you see this, the lecturers usually, the people who are marking, okay, it's human nature, they're busy. Like when umeanza na take notice, they know this person knows your stuff. And then now the next thing they'll come is check your order. So we're looking for an application for, we're doing an application for injunction. How would you lift your order? First of all, okay, this is something that we didn't do it because I didn't begin with it because I just want to rush into the difference between a chamber summons and a notice of motion. But I presume, as a diligent advocate, you will move to court under certificate of urgency. Yeah. So the first order normally inakuwaga ni that this honorable court certifies this matter as urgent. Leave it as plain and simple. Yeah. How will you draft the second order? You're just looking for an injunction that this honorable court will issue a temporary injunction against the first and second, there's no more first against the the defendant, respondent, restraining them, now can put jointly and severally their agents, employees, and/or servants. Never include easy with the and/or in legal writing and drafting, and/or servants from a victim. The who? The plaintiff stroke applicant. And the last one is that cost of this would be provided for.
So Lonka, please increase the font a bit. They're too small.
Okay. Can you see now? Is it better?
That's so much better. That's okay. better, yes.
Yeah, so that's it. And then now after you're done with that, you come down here and you write which application. I know there's some lecturers who teach you how to draft, but Sisi, when we were there, we were taught a lot of theory, but we weren't sure how to draft these things in particular. So I hope it's being helpful. Even though it's a good practicing. It's a good practicing. You can practice it. Which application is based on the following grounds? Now, on the grounds, you're given a fact. You've been given the facts. What you're going to do on the grounds is just reiterate those facts. You know, that blah, blah, blah is currently staying here. And then the threat, there is a threat of evicting her. Here you're just giving a narration. Yeah. So I won't even. The grounds is just a narration of the fact you've been given to support your application for injunction. Yeah. Now, there kuna, and then now normally here you can write and which application and this application. It just depends on how you will do it. And which application is further supported by the supporting affidavit of who? Now, who's the plaintiff? The plaintiff was Esther Kimani. The supporting affidavit of Esther Kimani and such other grounds as may be adduced at the hearing. Yeah, and we're done with the application. So the last thing you do is dated at Nairobi is dash day of dash 2021. And then after you're done, okay, normally down here, there's usually that place, right? So who will be the law firms will write mockups from? Advocates, the plaintiff, okay, this is usually down here. After dated and dated at Nairobi, etc., it's usually down there. Is misbehaving. Yeah. So this is it. Now, once you're done with that, there's a question that's coming. Now, as we go on, I want you to tell me what's missing in this application. So let me try and shrink this thing into one. Let's put it to one page. Yeah, so this is the application. What's missing in this application? Anybody, please kindly, because I can't see what's missing in this application.
The case number.
Yeah, case number. You'll put the case number, yes, if you've been given in the exam. What else? Something very crucial.
Yes.
If you don't have it in your application.
For every
Hello, Brian.
Yeah. Hello, who's
Yes,
speaking? Hello.
Yes, it's Joe.
Okay,
Yes, there is this statement that is usually indicated after to be served upon, and I had it in my mind. Nimepotea tu saa hizi. It's it's a statement that is nimesahau. I'm forgetting that statement.
Okay. I think Harriet.
the statement states, if any party does not appear at the time in place above mentioned, such order will be made and proceedings taken as the court may think just and expedient.
Exactly. Now, what's the provision for it? Inatoka wapi hiyo kitu?
Order 51 rule 13.
Exactly. So this is the proof. This is the, so in an exam setting, never miss that statement because it has marks. It's provided for under order 51. Provided for under order 51, all that in here. If any parties, I'll actually just copy paste it. Every application shall bear those words. So it's mandatory. You had all gotten it correctly. George, all of you have gotten it correctly. So you bring it down here somewhere. Note. It is. The application is complete. Yes, yes.
That particular provision that you're writing there, it's called a penal notice. So
yeah.
Learning friends, kindly, because it's a common question in the orals, so it's called a penal notice.
Yeah.
And then the other thing, someone mentioned something to do with case number or something. You see, by the way, this matter hasn't been filed, okay? So only matters that have been filed before the court bear the case number. So reason why, for me, what I was taught and what I drafted in the exam room, you see the reason why you don't put a case number and then down there now trying to put in the name of the firm that perhaps prepare this pleading. I didn't write, filed by, okay? Mine, by the way, all through was just drawn by the name of the firm, the address, and everything. So I think when you indicate filed by, you see, I mean, the case is maybe proceeding to the for assessment first at the registry and then get filed. Okay. So I don't know how your lecturers have taught you, but for me, never, ever have I indicated drawn and filed by. I'd always write drawn. That's it. But I mean, it's a profession with dynamics. So it all perhaps depends, but in an exam room, you will never file this matter. It's mainly for academic credit, and that's it. So just to be safe, you could just indicate drawn by. The rest is history. But again, as I say, it's a profession subjected to, dynamics. And at the end of the day, you just have to, have yourself perhaps a cogent pleading for the purposes of scoping as many marks as you could. So that's all.
Yeah. That's a good it's a good observation. It depends also on the facts, so you can check. Like, but for instance, you see, if I think the one who answered that was coming from, I said I said actually it's filed in court. Even if you check our question 1 for last year, there was already a high court ruling on that matter, so there's already a matter. So in the exam setting, they've not given you a case number. It's not, you don't have to put it there. Drawn and filed by, no harm in putting it. If you leave it out, at least they've seen you put drawn and filed by. Literally, the marks, where the marks are here. Have you properly described the parties? Have you properly identified the proper court? Have you properly identified the law? Have you crafted your orders very well? Have you listed your grounds? No, your grounds, I just told you these are just narrations. And have you provided for all these? And then this thing over here, they usually check it a lot. They make sure you have a penal notice. Every application you draft, make sure it has a penal notice. So that's a notice of motion application. Yeah? I won't draft a supporting affidavit right now. I want us to move quickly to a chamber summons application. Yeah. Now, I asked you a question on addition. Yes?
Yes, just a quick one before you move.
Okay.
This document, for purposes of exam, on the signing part for the advocates for the plaintiff, do you need to sign or you just leave it that way?
Actually, sign it. We were told during exams, I don't know, but I signed mine in exams. Sign it. Make sure you sign it.
And the date?
Where? Or don't, yeah, you can put the exam date and all. So for me, I did all this during when I was writing or answering my questions. The application I drafted in question 1 in civil litigation, I signed it and I dated it.
Okay, my question was, is it on the grounds that you put that statement that the applicant is likely to suffer irreparable damages, or in case the injunction is not given?
Yeah. Okay. Now maybe we can craft. Okay, I gave a short story, but what are some of the grounds that you will raise? Let's just put them here. That the applicant resides in X. Just telling a story from the fact you've been given. XXX. Applicant resides in this. Where do we call it? We call it Maua or something. In Maua. Apartments. Because see in your application, you are trying to you're making an application for injunction. So you have to show that this thing there's some form of urgency in this matter. That what my colleague just rightly put out. That you can mention there's a pending case in court, depending on the facts. But yes, you have to show why there is. You have to establish the grounds of those issues in Giela versus Kasman Brown. The applicant seeks to be evicted by the defendant XX. Now will suffer if this so here in the grounds, when you're giving the narrations, you have to bear in mind and remember the principles of Giela v. Kasman Brown. And the most crucial that is pertinent to this particular case is the aspect of irreparable injury that cannot be remedied by monetary damages. You can even bring out the issue of the balance of convenience and so forth. But you see, who determines the balance of convenience? It's the court. So for you, you're just going to state, but it's the court who determines it on the balance of convenience. So yes, you're right. Those are some of the grounds you will bring. That unless the remedy is sought, granted, plaintiff, stroke applicant will suffer irreparable harm and injury. Does the application make sense now? Does it look like it makes sense? Like I've not completed it because the grounds are just giving the narrations of the events.
Salonka, you're not project. Did you mean to project? You're not projecting?
Oh, sorry. I'm really sorry. I thought I was projecting. If you heard, I was typing. So I'm so sorry about that. Yeah, so I was changing it. I was actually typing the grounds. Can you see the screen now?
We can see now.
Yeah. So resides in these 6 is about to be unless the remedy is sought herein will suffer irreparable. Those are some of the grounds you will bring, depending on the facts. Yeah, depending on the facts, you will put them in the grounds. But remember, the grounds are to be. It's in brief. You're giving your facts in brief. You're narrating your story. If I can say, you're narrating your story in brief. The substance of it will be found where? In the supporting affidavit. Yeah. So I'm seeing time is going. Let's go quick and draft a chamber summons application from the question I had asked you. There's a question I asked, what will you do if you had sued the wrong party and you want to bring in a proper party? How will you go about it? Somebody answered it correctly. So you could just repeat the answer. How will you do it? How will you go about it? You've sued person X, then later on you realize you ought to have sued party B. How will you do it?
Brian?
Yep.
Yes, if I may answer it.
Yeah, please go ahead.
Yes, you'll have to draft a that party note. You'll have to enjoin the other that party by way of by filing a that party notice, and that application is by way of chamber summons.
By way of chamber summons.
And we will have to annex. Yes. Yes, and then you'll have to attach the. You'll have to attach to annex. That's the correct terminology. To annex the draft that party notice for that other the motorist who caused the accident. The other that party that is.
Who caused the accident? Yes. Now that is for that parties. That's a chamber summons. Yes. Now I was asking on substitution. You've sued person X, but then you realize you should have sued person B instead of person X. How would you go about that also? For that party, you've gotten it correctly. Now you want to remove person X and bring in person what? Person B. And this is a question that is usually tested. You're told that this person instituted a suit against the wrong person. He wants now to institute against the proper person. How will you go about it? It's here in order 1.
Chamber summons.
Chamber summons. The concept is known as addition and substitution of what? Of parties here. Yeah, substitution and addition of parties. You file an application in court. What application do you file? Order 1, Rule 14. It expressly provides that you file a chamber summons application. This is it. Yeah. So you come here and let's proceed and draft. Let's do, because this one is a bit simpler. Let's do an application to substitute. An application to substitute. Or not to substitute, let's do an application to add a party. So let's say you want to add a substitution and addition. So let's say there is person X. Okay, let me just, because of time, let me just copy paste this heading. It won't change. We're drafting now a chamber summons application, and you want to add who? You want to add you're filing an application in court to enjoin. Do we enjoin Arunga? This thing will change. So you're adding, okay, this is not an application. Take note, this is not an application to bring in that party proceeding. You're not enjoining a third party. Who makes an application to enjoin a third party? It's a defendant. Now for this one, you're bringing in an additional party. Huyu mtu hakuwa kwa hii kesi, but you want to add him. You can read order 1 rule 10 to understand it, but I'll just show you how to draft these chamber summons application. Later on, eventually, we will see the wording. So you're just adding, How will you go about this case? So it's what? It's a chamber summons application. So you write there chamber summons. What are the provisions of the law? Somebody. Order 1 rule what?
Order 1 rule 14.
Rule 14.
Order 1. What about rule 10? Will order 1 rule 10 fall under that? Yes. Actually, so you just put it to order 1 rule 10 and 14. 14 is also there because 14 provides for the application. Okay, let me just put it in for order 1 rule 10. 14 and Now, because the ones, actually, even if you don't know what you put, easy to section 1A. 1B, though it's a bit risky. There are some applications you cannot move the code, but okay, people just put it there. But personally, my view is if a code provides for an express way of you approaching the code, don't rely on the inherent powers of the code at all. Inherent powers in section 3 of the civil procedure rules. And that's it. So how does a chamber summons application begin?
Let's
Let all parties.
Yeah. Let all parties concerned attend the honorable what? In what? In chambers. The dash day of dash 2021 at 9 o'clock in the forenoon or soon thereafter. As counsel or others write it as counsel for the applicant shall be heard on an application for the following orders, or you can write soon thereafter for the hearing of an application. So for the applicant for orders, then now you go on ahead and list your orders. So if you moved under certificate of urgency, that this matter be certified as urgent. If not, just go on ahead and say that the applicant be that the respondent be added as an additional party to the suit. Now, depending on the facts of the case, they may bring a question of maybe you're substituting. So the template is the same. You'll just draft let all parties. Now, what will change is the wording. Yeah? So, for instance, the wording using the act. We usually use the act to change the wording. So, for instance, Order 110 provides where a suit has been instituted in the name of the wrong person as plaintiff, or where it is doubtful, whether it has been instituted in the name of the right plaintiff. The court may at any stage be satisfied that the suit has been instituted through a bona fide mistake, that it is necessary for the determination of the real matter in dispute to do so, order any other person to be substituted or added as plaintiff upon such terms as the court deems fit. The court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, here it is, improperly joined, whether the plaintiff or defendant, be struck out, and that the name of the person who ought to be joined, whether as the plaintiff or defendant, or whose presence before the court may be necessary to order, in order to enable the court effectually and complete and adjudicate, be added. Yeah, no person shall be added as plaintiff without a friend, etc. So what they're saying is you can substitute or you can add a party. So in our question, if let's say they wanted you to substitute or remove a party, what will your prayer be? That the first respondent be struck out, that the first respondent be struck out, and the second respondent be joined in the suit here, something of the sort. Yeah. So that's how you will go about that application. It's just about changing the wording, but the format of the template remains the same. Yeah, I hope you've understood up to there. It's just changing the wording of the orders you're seeking. If it's only adding, that this person be added. If you're only removing him, or if you're only making an application for removal, you'll just say that this honorable court proceed to strike out so and so and so. That this honorable court proceeds to strike out and substitute in his place the second respondent. I hope that's clear. You can just, is that clear on how you'll go about that, how we'll go about it? If let's say they twist the question and there is an issue of substitution, There's an issue of addition, or maybe there's an issue of striking out a person. If it's striking out, that the applicant be struck out. If it's substituting, that the applicant be struck out and substituted, and the second respondent be substituted therein instead. If it's an issue of just adding, just add the person. So the cost of this should be provided for. And
sorry, Brian.
Yes.
I just had a question before you continue.
Please,
There
please
was, you had said something about in some instances it's the defendant who makes the application either to substitute or add. So could you clarify?
Okay, yeah. I was talking about that in relation to that party proceedings. Let me just finish this and then because it's actually fairly done. So this one, this is different. We're looking for injunctions. So which application is based on? Let me just finish and expound on that. Higher. That's it. And that's how your chamber summons application will look like. Yeah. Plaintiff or applicant. Yeah. So that's how your application will look like for additional substitution of a suit. This is a chamber summons application. Now, you asked the question of the issue of defendants. So I talked about that when George had answered the question on he had answered the question of that party proceedings, and the issue was on the difference between that party proceedings and substitution and addition of parties. There are two different concepts. When you look at that party proceedings, it's under Order 1 Rule 15. Here it is. Who makes an application for a person to be enjoined as a third party? It's a defendant who claims indemnity. Sorry, yeah, it's a defendant. A plaintiff cannot make an application for enjoyment of a party of somebody as a third party. Yeah? As a plaintiff, you can't. The only person who can make an application for somebody to be joined as a third party because he either claims contribution or indemnity from that person is a defendant. From the wording of Order 1 Rule 15, where a defendant claims as against any other person not already to the suit hearing, called the third party is entitled to contribution and all that. So it goes back to the facts I had given. So let's say you hit somebody while you're on the road. And the reason why you hit that person is because somebody else had knocked you from the back, and that forced you to go and hit another car in front. What will you do? What will be a recourse? You will go to court. Okay, the person you hit has sued you. What you will do is you will file an application to enjoin the person who knocked you as a third party, because what you're saying is, I am not liable. The only reason why I knocked this person is because you knocked me from the back. So you are the one who is liable to pay that person. That is a third party proceeding. But under Order 1 Rule 10, substitution and addition of parties, this is where, let's say you've instituted a suit in the name of the wrong person, and you need to remove that person from the suit and bring in the right person. What will you do? Substitution. Or you've instituted a suit against a person, and then in between you realize, okay, there's another person who's not in this suit, and he needs to be added for the court to properly adjudicate and determine this matter to finality. What do? You file an application to add the party to the suit. Or maybe you've sued two persons, and then later on you realize you don't have any cause of action against the first person. What do? You do an application for that person to be struck out. That's the difference between Order 1 Rule 10 and Order 1 Rule 15. Have I answered that one too? I've answered that one sufficiently.
Yes, thank you.
Okay. Now, this is what now we're coming to an end. I'm so sorry we've taken so much time, but This is it. This is a notice of motion application. This is how it looks like. This is a chamber summons application. This is how it looks like. And this is a question that I was asked in my orals. Why would you use a notice of motion application and not a chamber summons? Or maybe they give you a factual scenario and they tell you, draft, what is the proper document to be filed in court? This is where you answer. This is where you provide. This is the background to it. You use a chamber summons application when it is expressly provided for in the statute. And all those instances where you use chamber summons, you will see it's expressly provided for in the statute. By expressly, I mean statute inasema move the court using what? A chamber summons. For instance, Order 114, what does it say? An application to add or strike out or substitute a plaintiff or defendant may be made to court at any time before trial by chamber summons. This is where you use a chamber summons application. But let's say a statute is silent. A statute is silent. It doesn't provide for the type of application you should draft when approaching the court. What will you do? Recourse is found under Order 51 of the Civil Procedure Rules. And under Order 51 of the Civil Procedure Rules Rule 1, it says, all applications to the court shall be by motion and shall be heard in open court unless the court directs the hearing to be conducted in chambers or unless the rules expressly provide for. Meaning, a notice of motion application is the default application. Sorry. Yeah, and I'll give an example. We've done an application for injunction. There's an application for stay of execution. What are the circumstances where you will use a notice of motion application? We've done injunction, there's stay of execution, there's summary judgment. Which one else? There are so many. The list is inexhaustible. So those are the circumstances where you will use a notice of motion and where you will use a chamber summons application. I don't know. It's getting to 11. So tell me what. Arunga, you have your hand up.
I have a question.
Yes. Please go on.
In that application for additional institution,
yeah.
I believe the next procedure after the court has is supposed the party who is making the application is supposed to his or her pleadings.
Yes, you have to amend your pleadings.
Yes. So in circumstances, can you put as part of the orders?
Can you put
as part of the orders? In that application, that the honorable court be pleased to allow the amended, for instance, let's say it's the plaintiff. The honorable court be pleased to allow the amended plaint that is attached or annexed.
That's an interesting question, Arunga. That's a very interesting question. Now, the issue will be, how do you move the court to amend your pleadings? It's provided for under Order 8 of the Civil Procedure Rules. There are two circumstances. There are two circumstances where you may move the court when you're amending pleadings. With the leave of the court or without the leave of the court. Before close of pleadings, you don't need to seek leave of the court. But now, since we've already filed, we presume that the pleadings have already, that the close of pleadings has already happened. So you will need to seek the leave of the court. Which document will you use when you're making an application to amend your pleadings? Maybe it will be an assignment. It's okay under Order 8 of the Civil Procedure Rules. But I do get your question, because you see most, and I've seen it actually in practice. What happens? They say that this honorable court grants leave for the plaintiff to amend his pleadings. Grants leave for the plaintiff to amend his pleading. They put it all in one application instead of going and bringing back another application. But then you see, before you amend your pleadings, and this is why, before you amend your pleadings, you need to seek leave of the court. The court needs to give you leave to amend your pleadings. You can check Order 8 of the Civil Procedure Rules. Yeah, maybe you can check Order 8 because you could put it in your application that this honorable court. I think you could put it in that same application. But then the other question would be, when you're seeking leave to amend your pleadings, what do you use? Do you use a notice of motion or do you use a chamber summons application? Some lecturers are also conflicting. I've seen others doing chamber summons. I've seen others doing notice of motion. Assignment. We'll begin with it from next week. Odora, and then Waru, and then Joe. Okay, in that order.
Okay, then again, what about again the fact that in Civicon Limited versus Kivuat Limited and two others, it was held that the court the decision to add a party or to enjoin a party is at the discretion of the court. The court may allow it or not. I mean, I think that means that you have to allow the court to either allow you to join this party or not, before you tell the court that you want to amend the pleadings. So I think they have to be made separately.
Yeah. Okay, that's a very good one. It's a very good one. Yeah, you have to give the court to allow you first. But then you see at the same time, I think Arunga will draft his pleading like, under the third order, maybe seeking leave to do what? Seeking leave to. Okay, he's not seeking leave to amend. He wants to add a part in that. Is that order? Maybe he crafts it in a manner like that. If leave has been granted under 2 above, this honorable court be pleased to hereby, etc. There's a way you could craft it. It's something I've seen in practice, but in the interest of justice and all, you can bring in 159 and due delay. There's no need to file a chamber summons, come in again and file a notice of motion, file another application. If you can converse all those things in one particular omnibus application. But then there are also many judgments that say don't file omnibus applications they're against filing of omnibus applications such as those. And John?
Making an application. When application to chamber summons, when do you do it ex parte, and when you do it ex parte, do you need to add the penal notice?
When you do ex parte?
Yes.
Okay. Hi. Now, let's take an instance where an ex parte application is usually drafted. We can do Order 1 rule, that party notice. Order 1. Order 1 party. Let me just. Order 1 rule 15. It's here. I've opened it. So you see, it's usually an ex parte application. It's usually done ex parte application in chamber summons. But then when you go read Order 1 rule 15 sub rule 2, a copy of such notice shall be filed and shall be served on the third party according to the rules relating to the service of summons. Even if it's an ex parte, even if you're doing an ex parte application, more or less the other party will also be heard and you'll have to serve him. So you'll just put the penal notice pursuant to Order 51, which says, it says the word shall means mandatory and all. So I will just put a penal notice in all applications just to be safe. Because, for instance, you've checked Order 1 rule 15. Yes, you're doing it ex parte, but subsequently you have to serve this other party. I think I will put the penal notice there also. Who else has a question? Now on feedback. Okay, today I know we didn't do any oral mockups. Was this session helpful? Did it help or guide you a bit?
Yes.
Yeah, please just go on. Just go on and speak. Today most of my colleagues were a bit held up. That's why. Okay, I didn't know that, but I thought we would do it in 1 hour, but then apparently it took some bit of time. Was it helpful? Like, do you have?
Just a long time.
Yeah.
I think it was very, very helpful, and thank you so much for taking your time to just speak to us and to just encourage us and also to show us what we are supposed to do. May the Lord bless you so much. Thank you so much.
Karibu. Esther, please go on. Who's talked?
It has been helpful, especially for me personally, because I still have a problem with drafting right now. With a lot of practice, I know I'll be better, but it has been helpful. And also you've shed light when it comes to answering some of these questions in orals, especially those case scenario questions, and how to literally, have a grasp for especially the rules. It has been helpful. Thank you.
Thank you for that. Thank you for that. So maybe next time during the week, because today we've done civil. Personally, for me, I am okay with the civil, conveyancing, criminal, and commercial. You could throw in questions or areas you want us to address. Then we will be doing it. We'll do it for the first 1 hour. Just 1 hour. I think we digress, but it's actually a good thing because I was alone. So we'll do it for the first 1 hour. Then my colleagues and I will now proceed to do the oral mockups for the remaining 2 hours. So for the first 1 hour, maybe Lavin was supposed, but today he was a bit held up. So next time he will start off with the presentation he had on the LSA. So if you have an issue in commercial, if let's say you want us to do mergers and acquisitions, you could give us, just hit us up, and then now we do it. Just in brief, just guide you where to look at. So today we've done 2 main applications. You may think that is small, but in exam situations, I don't think there's a circumstance where you will miss a question on drafting either a chamber summons or a notice of motion application. And I've showed you how to get the law on what to draft, checking the civil procedure rules, and I've also showed you how to check basically just everything we've done today. So I'm hopeful that during the exam setting you will learn how to go about it. So I think it's late. Lavin, do you have anything to say? It's a bit hard up. So next time we'll do. Go on.
Thank you. I think today has just been that day. It's sort of the craziest, but for the few times I've joined, I think it's been as encouraging as possible, enlightening, involving, and insightful. So I think within the course of the week, if you have anything that perhaps you feel stuck at, we're always free. So you can just hit us up. Yeah, the presentation I was supposed to do for LSA, it's hard to do it right now for the sake of time. So I'll do it next coming week, inshallah. And yeah, for conveyancing, commercial, like we're open to anything. Don't limit yourself to, this particular issue or unit. A challenge is a challenge. So regardless of the unit, I think we're just approachable, we're reachable, and useful to you. So that's all. And I still wish you the best in your ATP. Put God first, wisdom, have fun, try and balance at the end of it all. But I'm still praying that he will pass. So yeah, that's it. So Perino, it was real. Even when today you've had an entire monologue by yourself, I appreciate that and thank you. for perhaps covering up for us. Yeah, so that's all. That's what brotherhood is all about, and that's what teamwork is all about. So next time when Solonka is a little bit indisposed and perhaps incapacitated, I think we will perhaps step in for him. So yeah, so I hope whatever he has taught you, today has been insightful and eye-opening. So keep reading, by the way, keep reading. And by now, I think you should be done perhaps reading Land Registration Act. I think it has 110 or so sections. Yeah, with the analogous rights being the last of the sections. Yeah, so just read it for fun, okay? And try and balance with the rest of the units. Don't focus so much on the strengths. Look at the weaknesses in each and every unit and try to perhaps journal them down. You just write them down so that when we're here and when you feel stuck, you are at liberty to try and perhaps, ease yourself of the burden of, carrying too much work on your shoulders. So yeah, so thank you and have a blessed night. Thank you.
Thanks a lot. Osman, your hand is up. Please go on. Let me close up. Thanks a lot, Lavins. Osman could close up for us. Also, next time we'll do all these documents. So don't stress. We've done these two. We'll do a petition. We'll do a plaint. We'll do all this criminal. We'll do them also. Lavins is good in criminal. We will do conveyancing. We'll do commercial. We'll do everything to help you guys pass. So we'll do it. Osman, go on, then we close.
Okay, thank you very much, Hareno, and for the class of tonight. I've been grateful for you and for your noble work. I think the drafting part of tonight's class was helpful and thoughtful, at least. So I was suggesting if you can at least the 4 subjects you have stated, that is the criminal, the conveyancing, and commercial, and adding this civil, at least you are the one who knows what kind of documents are supposed to be drafted and they usually come to are tested in exams. Then at least the way you have done tonight, by drafting physically in front of us a notice of motion and temper summons, if you can also do when it comes to other units, for example, commercial, what are kind of documents that are tested or supposed to be drafted, commercial, conveyancing, all of them, and also criminal. Personally, for tonight's class has been very helpful, the drafting of those 2 documents. Thank you very much. I was suggesting if you can do the other units too. Thank you.
Yeah, that's fine. We'll do them. It will even reach a point. Once you're done with orals, what we'll be doing is past papers too. So we'll start doing past papers, and the good thing is they repeat these things. So yeah, we're here. As Lavin said to Kohaba. We'll do it, Kapisa. Okay. Let's go sleep. Then we'll see each other tomorrow.